What's up, everybody, and welcome back in. We are checking in on the Brian Kohberger case. We're going to take a look at the scheduling order, which is officially out and gives all the deadlines and dates when everything is going to be due, pushing the state, pushing Brian Kohberger to get this case to trial by June of 2025. We're going to talk about whether or not we think these deadlines are actually doable that have been set by the court. We'll talk about some interesting potential conflicts in some of the dates where certain things are due and how the court has built in known delays and issues that we can all expect in a trial like this. And hopefully all that will help us get to trial by June of 2025. So hit the like button if you haven't already. Make sure you're subscribed to our page and throw your questions in the comments as we go. So we're first going to take a look at this scheduling document, which the purpose of a scheduling order is to let the attorneys know what the expectations are, when things need to be done in order for this case to get to trial on the trial date, builds in some buffers, but also tries to hold the attorneys accountable so they don't delay, they don't waste time. And if they do, the judge can hammer them on it. And they could technically be violating a court order if they do things purposely to delay the case and create a situation where they can't go to trial on the scheduled date. And if the state does it, we've seen it in other cases in Idaho, make them forfeit the death penalty process of this case. And we're going to see that in here and see if that's a potential issue that comes up. I think the state seems prepared in this case. They seem to be ahead of the game. It's not a speedy trial. Kohberger has waived his right to a speedy trial at this point. So I don't think it's going to be the state that's delaying this case, but there have been issues with discovery with the FBI in the past. And we'll talk about when that is going to be zipped up and done and not allowable anymore in this case based on this scheduling order. So first, the official start date of this trial is going to be June 2nd, 2025, 8:30 a.m. in courtroom number 3 of the Latah County Courthouse and will run through August 29, 2025, literally the entire summer on an 8:30 to 3:30 p.m. schedule. Okay, so a bit of a shorter day. The reason there'll be a morning break, afternoon break, lunch break. And the reason for that is probably twofold. So they have time to handle issues at the end of the day. If something pops up, if we need to have a Daubert hearing to talk about a new expert or an expert that we haven't had a chance to challenge yet from either side, that could be one of the reasons. And number two, to allow the court to have other hearings, other motion hearings, other pretrial conferences, move his other cases along the last hour and a half or 2 hours of each day, depending on what the rest of the schedule is for the court, for the prosecutors, for the defense attorneys, for everybody involved. It just allows you to continue to try to move your cases and work on other things while you're in trial for 3 months, basically. These dates are inclusive. Trial will not be held on June 19th or July 4th, holidays in the middle of the trial. These dates are inclusive of jury selection as well as any sentencing phase that may be necessary. So it might not go till August 29th if it's a not guilty verdict, or if the sentencing phase goes quicker, like in Chad Daybell, where they just waive mitigation. Who knows? The defense's motion to change venue is currently set to be heard on August 29, 2024, so almost a full year before the trial, which gives us plenty of time if we change venue not to have any issues. If that motion is granted, the court anticipates that the trial dates will not change, although the location of the trial will. A final pretrial conference will be held on April 3rd, 2025 at 10 a.m. So what's interesting about this is the vast majority of pretrial conferences, and I don't know if Idaho is different, I'll just say for my cases, happen 1 month before the trial. Sometimes even closer to the trial, because we want to make sure we're going to go. This is when we ask the court, hey, judge, how many trials are ahead of us? Do we actually think we're going to go to trial? Can I tell my expert witnesses there's a 75% chance or 50% chance we do go or we don't go to trial, so everybody can be prepared, we don't waste our time and money? That's not going to happen here. This case will take precedent over every other case. So they are living in the number 1 slot, so they don't have to worry about any of that. But still, the court's giving them 2 months. In my opinion, this is in case there are major issues. There's something that's going to cause a delay, and we don't want it to push back the trial date. So that's why we're doing it 2 months ahead of time. Any motions challenging the death penalty shall be filed on or before September 5th, 2024. That's only 2 months away. Any responses shall be filed on October 10th. And then if the state wants to reply, they have 2 weeks, October 24th. And then we're going to have a hearing on those motions November 7th, 2024. So this stuff is about to start moving. These are incredibly important motions. I expect the defense to make some argument about delaying in discovery and violating a speedy trial, comparing it to Lori Vallow's case. He had to waive a speedy trial because this, therefore, the court should take the death penalty off the table. I think it's different circumstances, so I don't expect that to happen, but I think that's going to be at least one of their arguments, among others. Next, motions to suppress evidence and any other 12B motions shall be filed no later than November 14th, 2024. Again, 4 months away. Responses filed by December 19th. So each side, they file the initial motions to suppress, then each side, or the defense will file a motion to suppress. Then the state will respond to the motion to suppress by December 19th, and then replies to that January 10th. And then we're going to have that hearing, which could be a big hearing. If they try to suppress the DNA on the knife sheath, if they try to suppress any of the digital or forensic evidence, this is when we're going to hear about it in November. Responses in December, replies in January. And just in case you're the initial motion, then the response, then the reply. The person replying is the same person that filed the initial motion. Then the hearing's going to be February 6th and may continue to February 7th. The court thinks we're going to have some motions and some arguments there. Then motions in limine, which is to exclude certain evidence from either side on February 13th. Responses March 13th, replies March 25th, and a hearing on March 27th. So this is all, pushing a little further and a little further, a little closer to trial. But the court said we're going to include any 404B notices. So in case anybody's forgot what 404B is from the Murdaugh case, let's take a look here. 404B evidence is other crimes, wrongs, or acts. So are they going to bring in any other prior bad acts or crimes of Brian Kohberger? Now, they can't use them. The prohibited uses or evidence of any other crime is not admissible to prove a person's character in order to show that on a particular occasion, the person acted in accordance with their character. An example of that is he helped the girl fix her camera in her room, and then she felt like somebody was spying on her or broke in or something like that, which has no real legitimate connection to Brian Kohberger, no prior conviction, nothing like that. It's not going to come in. That would just be to try to say this is the type of character he has to spy on, college females and, do creepy stuff, basically. Not going to happen. Permitted uses. So if it does exist, how can they use it? It may be admissible for another purpose, such as proving motive, opportunity, intent, preparation, plan, knowledge, identity, absence of mistake, or lack of accident. So if they were going to try to use that, they could say, well, it shows this is the way he does it through cameras so he can get in and out without being noticed, without being suspected. Highly doubtful. Okay. Then they go through the notice requirements, but all that has to be done by March. And that's when they have the final hearing on those types of notices is in March. Okay, March 27th. Now, a very interesting one. Discovery completion. That means anything that is just reasonably believed to lead to discoverable material that the other side asked for, or even that you believe you're going to use at trial, or is Brady information that's exculpatory evidence, or could tend to prove the defendant's innocence. The state has to turn all of that over by when? September 6th, folks. That's only 2 months away. And there's a lot of stuff still pending. A lot of stuff the state has still said it either doesn't exist or the FBI says it doesn't exist or we haven't turned it over. There's a lot that the defense has said the state has not turned over yet. And that's all supposed to be done by September 6th. I find that hard to believe. Now, what's interesting is the defense's discovery deadline isn't until January 9th, which gives them ample time to respond to anything the state turns over at the last minute. It gives them time to go through, figure out what they need to do, what they need to disclose if there's anything more. The defense gets a little more leeway. They have a lot less discovery, right? They have a lot less of the information and the stuff in the case because the state's in control of most of it. And we'll talk about how other deadlines may potentially conflict with those discovery deadlines. Disclosure of trial experts. So a list of experts along with a copy of the expert report consistent with I.C.R. 16b7 and a copy of the expert's CV the state intends to call at trial shall be disclosed to the defense and the court by December 4th. So those experts cannot be relying on any new discovery that the defense doesn't already have, because they would have already gotten everything by September 6th. They can provide reports. They can be working. Maybe their depositions taken. I don't know. Working with the state between September and December, but no new discovery can come out. So let's take a look at I.C.R. 16b7. So what does this have to look like? What does the state have to do with these experts by December? Okay. So Idaho Criminal Rule 16B right here. Number 7 right here, expert witnesses. On written request of the defendant, the prosecutor must provide a written summary or report of any testimony that the state intends to introduce at trial or at a hearing pursuant to Rule 702, 703, 705 of the Idaho Rules of Evidence. Now, what's interesting is you'll notice here that the state intends to use at trial. You do not necessarily need to disclose written experts or certain information on just written reports on just consulting experts that maybe you've talked to, maybe have helped you prepare, but you don't intend to use at trial. The summary provided must describe the witness's opinions, the facts and data for those opinions, and the witness's qualifications. Disclosure of expert opinions regarding mental health must also comply with the requirements of Idaho Code 18207. The prosecution is not required to produce any materials not subject to disclosure under this section. Under subsection G of this rule. This section does not require disclosure of expert witnesses, their opinions, the facts and data for those opinions, or the witness's qualifications intended only to rebut evidence or theories that have not been disclosed under this rule prior. So they do not have to provide anything that will rebut things that have not been disclosed yet. Okay? Then we pop back over to the scheduling order and take a look at what the defense has to do and when. A list of the experts, along with a copy of their report, consistent with I.C.R. 16C4, which we'll look at, and a copy of the expert's CV has to be disclosed on January 9th. So this corresponds perfectly with the defense's discovery deadline. So they can be providing discovery and giving discovery to their experts all the way until January 9th. Why? How is that fair? Because they don't necessarily know all of the state's evidence and discovery until September 6th. The state knows or should have known about it far before then, and they still have 2 months. But the defense needs to work with their experts, see if there's any more discovery, any articles, anything they need to use, anything they have, maybe some Kohberger statements, who knows, and apply it before January 9th. So let's look at I.C.R. 16C4 now to take a look at what the defense needs to do. So that was B. Then we get into little c here and paragraph 4. Expert witnesses. On written request of the prosecuting attorney, the defendant must provide a written summary of any testimony the defense intends to produce with those rules. Summary provided. Describe the witness's opinion, facts and data they used, witness's qualifications. The defense is not required to produce any materials not subject to disclosure under subsection H of this rule, or any materials otherwise protected from disclosure by defense's constitutional rights. So let's take a look at G and H, which were referenced in the rules. Prosecution information not subject to disclosure: work product, legal research, correspondence, reports to the extent that they contain the opinions, theories, or conclusions of the prosecuting attorney or members of the prosecuting attorney's legal staff, informants. Okay, then H, the defense information not subject to disclosure. Except as to scientific or medical reports, this rule does not authorize the discovery or inspection of reports, memos, or other internal defense documents made by the defendant or defense's attorneys or agents in connection with the investigation or defense of the case, or of statements made by the defendant or prosecuting attorney or defense witnesses or prospective state or defense witnesses to the defendant's agents or attorneys. We did experts, now trial materials. Proposed jury instructions shall be provided to the court by February 7th, responses by March 7th, pursuant to these rules. And then this is interesting. A closed, sealed hearing on the jury questionnaires will be held on April 2nd, 2025. Now, we know that there's a lot going on with potentially poisoned jury pools, the research being done by the defense, the surveys being done by the defense to potentially change the venue. I believe, and I think it's pretty obvious at this point, that that expert is also going to be intimately involved in the jury questionnaires and what questions the defense thinks needs to be on there. So all that's going to be happening in February, March. Then eventually we have a closed, sealed hearing in April that we won't be able to watch. Proposed jury instructions shall be filed with the court by March 14th. Jury instructions will be discussed at the final pretrial conference, which is in April 2nd, I think. So what's interesting about these is whenever we talk about jury instructions, verdict forms, things that pop up and they're like, how is this possible? Look, this stuff is all due March 14th. Why aren't we done? Because a trial is a living and breathing thing. Sometimes things change. Sometimes things need to be edited. And we try to be ahead of the game, but something almost always comes up and we've got to adjust on the fly. Lay trial witness lists shall be filed on March 14th. Now, it's kind of interesting to me how all the discovery is going to be done by the state and by September 6th. And it's 6 months later is the deadline for the witness list, which is kind of crazy to think. It's like, you know everything now. Why wait 6 months? Just to give them time. And we'll see about potential extensions in these deadlines and what happens if they blow these deadlines? What happens if they don't provide the rest of the discovery by September 6th? Is it an automatic sanction of some sort? Exhibit lists filed also on March 14th. Okay, so witnesses and exhibit lists, not experts. They're going to give them more time for experts, even though all the expert reports are due by December 4th. This witness list and exhibit list is just for lay witnesses. Each party shall prepare a list of exhibits that it expects to offer. Just because it's on the exhibit list, just because somebody's on the witness list, doesn't mean they have to offer it, doesn't mean they have to call them. Exhibits should be listed in the order that the party anticipates they will be offered. Again, not always perfect, not always how it happens, but we try. Each party shall affix labels to their exhibits before trial. Every court and clerk does this a little bit differently, so it's always interesting to see. Some clerks do not want you to pre-mark it, some do. The state's exhibits shall be marked with red labels in numerical sequence S before the number S1. Defendant's exhibits shall be marked with blue labels in numeric sequence with a D before the number D1. Again, to keep them straight. Should be easy, should be clean. It never is. Civil cases go so much easier. Sometimes we have a full binder that we all just kind of agree goes forward. Criminal cases, there's a fight about everything usually. The case number should also be placed on each of the exhibit labels. Exhibits should be lodged and served as required by the pretrial order. Exhibit labels can be obtained from a deputy court clerk. Counsel shall provide a copy of each exhibit and an exhibit list to opposing counsel and the court. Copies should be made after the labels are marked and attached to the original exhibit. To expedite the trial, each exhibit to be offered should be viewed by opposing counsel prior to trial and determination made as to whether or not an objection will be lodged against the exhibit. Again, we do this in every civil case as well, but in criminal cases, there seems to be a lot more objections. And how it looks is kind of like a chart. Exhibit number 1, picture of the knife, defense object, state object. If they do, they check the box, yes, and then reason for objection. They can go back and forth. They can agree. This one is coming in, so we stipulate that one's coming in. We don't agree on this, so we're going to have to argue in front of the judge. Judge will make a call, or, okay, fine, we both agree that's a legit objection. We're not going to try to enter it. We don't even need to argue in front of the court. So that's kind of how the chart looks, and the court should only answer the ones that one party objects or the parties don't agree, and the court has to make a call. Each party shall provide the court with a trial brief, which shall be filed on or before March 14th. So March 14th is kind of that deadline where everything needs to be done. All the issues, the trial brief is like, what's the case about? What are the issues we still have? What does the court need to decide? What are going to be the material facts we don't agree on in the case? What material facts do we agree on? Is there anything we stipulate to? All that's going to be in the trial brief, so the court knows it's to educate the court on everything that's going on in the case and every potential problem that could pop up. And this is 2 or 3 weeks before the final pretrial conference in April, because any issues that come up, we should handle them all there. We have 60 days before the trial starts. That's plenty of time to handle just about everything, because discovery's been done for 3 to 6 months, depending on if you're talking about the state or the defense. Expert stuff's been done for months. Witness lists are all in. Exhibit lists are all in. Your objections are all in. We know what all the issues are March 14th, so there's no reason by April 2nd we can have everything hammered out and take those last 60 days to make sure everything's fine-tuned and ready to go. Then we have sentencing, which is a big part of this case and not as big on every other case, because obviously it's death penalty case. There's 2 phases to this trial. Any witnesses, lay or expert, expert reports, and any list of exhibits with copies attached to the state intends to present in support of aggravation. Okay, this is the sentencing portion. Shall be provided to the defense by January 9th. So how does that date work or even conflict with the defense's discovery deadline? Because the defense's discovery deadline was January 9th. And so if the state can be providing aggravation evidence up until this, January 9th, how's the defendant supposed to turn all that in? Well, just like the state's deadline for this is months later than their September discovery deadline for the guilt phase of the trial, the defense's is also extended to March 3rd. And this is where I see the first potential problem. The defendant's mitigation disclosures, including a list of witnesses, lay and expert reports, and a list of exhibits with copies attached, shall be provided to the state and the court by March 3rd. So the defense doesn't technically have to turn over all their mitigation evidence until March 3rd. And then we're supposed to have everything ready in the trial brief and basically be done by March 14th. That's a pretty quick turnaround. That's less than the 14-day period the court has provided for all responses and replies to everything else in this case. So the state doesn't even have 14 days between the defense's mitigation, discovery and information and expert information and witnesses and the March 14th brief date, which is again 2 or 3 weeks before the April 2nd pretrial conference date. Any witnesses, lay or expert, and exhibits the state intends to provide in rebuttal shall be provided to the defense on March 31st. There's that conflict. How are we supposed to have a trial brief, Judge? If I was the defense, I would say, Judge, how am I supposed to tell you if we have issues in the sentencing portion if I don't even have the state's information until March 31st? If I don't have their response to our information. If I'm the state, how am I supposed to say, Judge, we have until March 31st to respond to all this. How am I supposed to have all the answers and what the issues are in the trial brief on March 14th? Unless the court doesn't expect to have the mitigation and aggravation factors in the trial brief that it wants and expects on March 14th, which I would think it would. So I find that to be interesting. But then we have the big kicker catch-all paragraph here at the end, filings after deadline. If you blow a deadline, if you don't get this done in time, what's your remedy? What's your punishment? Well, the court reserves the right to hear any motions filed after a deadline has passed if what? If good cause is shown, including but not limited to motions that arise after a disclosure made by the opposing party. So we go all the way back up here, and this looks really great. State's discovery has to be due by September 6th, but what if something comes out between September 6th and January 9th to where the state, oopsie, we have more discovery in response to the defendant's discovery. That's good cause shown, and it fits into this disclaimer by the court. Motions that arise or information that arises after a disclosure is made by the opposing party. And I could see it happening, obviously, here with the March 3rd and March 31st date being couched around everything else already done. The deadlines are already all passed, including the trial brief, and we're 2 days before the pretrial conference. I could foresee an issue. But I think the court was very smart in building 2 months in there from the final pretrial conference and the actual trial date. But if these deadlines are violated and missed without good cause, what remedies could happen? They could potentially lose the death penalty. The state, not the defense, lose the opportunity to seek the death penalty, which was a remedy found in the Lori Vallow case. The judge could strike certain witnesses or evidence or exhibits if it's not timely filed and they knew or should have known about it. If the defense turns something over January 10th if the FBI turns something over January 10th after both discovery deadlines have passed, the court could and probably should strike it because that's 3+ months after the state's deadline has passed. So that's an extreme remedy. They could also allow an extension of the defense's timeline to respond. They could allow the defense to take a deposition, have a Daubert hearing, do things to cure the late notice. But hopefully we don't have those kinds of delays and blown deadlines in this case. I think it's doable. What do you guys think? A full year, basically. I think everything is doable to be done by March. And again, if you remember, that's kind of the date the court wanted to do. And if you notice, a lot of these deadlines are couched in March and everything is done by April 2nd. So that it should be smooth sailing, right? 2 months before the trial even starts. It never is that smooth, but I do like how the court has built in some delays we know are going to happen. But what do you guys think? To a layperson, does that sound doable to you? And why or why not? Let me know in the comments. Please make sure you hit the like button on this case. Make sure you subscribe, hit the reminder bell so you don't miss any future Kohberger content or any of the trials that you're following. And let me know what's coming up, because I'm keeping an eye on the community page and other social media, Twitter, Instagram, to see what cases you guys are following, to figure out what's next. But for now, it's all we got. Till next time, I'm out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, The Lawyer You Know.